The next case is State of Ohio versus Jeanne Harrington. Both parties are present. Oh. Thank you, Kit. The case number is 16CA010961. And each party will have 15 minutes to present their arguments. Mr. Hannock, if you would like to reserve up to 5 minutes for rebuttal, please feel free to do so. Just let us know. It's always appreciated if you state your name and who you represent for the record, since these oral arguments are being recorded. Also, please try to stay behind the podium and keep your voice up. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, State of Ohio. My name is Nicholas Hannock. I'm representing the appellant, Jeanne Harrington. I'd ask to reserve 3 minutes for rebuttal if necessary.
Very good.
The arguments are on a manifest weight and sufficiency argument, and I want to touch on a few factual issues in this case that make this very interesting in that regard. This is one of the more unusual fact patterns in a murder case that I think anyone will remark during the trial and anyone any experience has seen. And the uniqueness of what is here and Jeanne Harrington, the defendant's interview, demeanor, life are very difficult to look around to get to what was presented and what happened here. First, the mechanism of injury was, as you know, is a saran wrap to the face. And what is interesting is the State of Ohio presents witnesses that say that Jeanne Harrington talked about this mechanism of injury to the deceased in this case. However, the defendant also presents someone who was a coworker who didn't know the other witnesses, who didn't know Jeanne Harrington, that says that he said the same thing, that I might kill myself someday in the same manner. And what I think that leads to look at is, this is something they talked about. I'm gonna, I might do this to you someday. Well, I'll do this to myself someday. This will happen this way. It's something that was on both the minds independently. Is it unusual? Yeah, it's about as unusual as anything can get.
Well, there was a distinction, I think. She had indicated that she would sit on top of his face. I think he just indicated that he would wrap his head in saran wrap or something like that.
And I think
was there evidence that there was trauma to the face that would indicate somebody sat on the victim's face?
Well, there is evidence of trauma on the face, and she actually admits to sitting on him, but not in a saran wrap context, which is a strange sentence to say out loud. But the issue there is, there was a fight that evening. She says there's a fight that evening. They fought before. He was convicted of domestic violence against her. This is about as troubled and unpleasant of a life that you could see through the witnesses. And that's hard for a jury to get around. She is a mean person. She says mean things about him. Does that mean she killed him? No.
Could you address, Judge Teodosio touched on it, the trauma to his face. I was a little confused, and we can ask the state the same thing, but I was a little confused about all the blood pooling around his face, because in your brief I didn't get the impression that there was really any trauma to his head or his face, but then from the state's brief it sounded like there was a significant amount.
There appears to be, in the record, there is blood in the face under the saran wrap. I don't think they presented evidence that really goes into the actual detail. In the state's brief, they talk about, well, there's no pooling of blood, there's no blood on the floor, there's no blood here. If that were laid out during the trial, that sure would have been really nice for the jury to consider. There's also, Ms. Harrington has a bite mark on her finger. She has marks on her, bruising marks on her arms. She admits to the altercation, one that they frequently had altercations.
But I thought there was testimony that he suffered blunt trauma to the head that would have been almost sufficient to knock him out.
There is it's speculated in there, it's not, I don't think it's as clean as the trauma would knock him out.
Well, what was in the record? What was it presented at the trial, I guess is what I'm asking you, so I'll just be direct about it. What
Understand.
evidence was in the trial about the trauma to the head?
There is, they speculate that it's possible that could have happened, it's also possible the Benadryl could have knocked him out. However,
So was there, who testified as to the physical trauma? If you don't know, that's fine.
I don't know, I think it's the coroner, but I don't know offhand.
Okay,
But the coroner, ultimate conclusion, and I'm not trying to, the ultimate conclusion is the coroner doesn't know.
I understand. He
Mechanism.
didn't know whether it was a homicide or a,
Right,
or
there's
suicide.
certainly Jeanne Harrington there was physical injuries committed to Mr. Gable from Jeanne Harrington. There's certainly physical injuries committed to Jeanne Harrington from Mr. Gable. There's an altercation that's admitted to, there's the stun, the light, lady light stun gun. There's the Benadryl, but there's no, this kind of rises to what is enough circumstantial evidence in this. And where I wanted to get to in this is sort of the fact, one of the things that are, yes, there's a lot of very unpleasant things about both of them. There's a lot of very negative things. The state pushes a lot to say, oh, well, he loved his child, and that would mean way against suicide. I don't think we really, I don't know if those arguments hold weight. The whole thing is very unpleasant, no matter which way you look at it. And what they presented to say that Jeanne Harrington committed this act, yes, there is those injuries. Yes, there's statements she makes that she doesn't like him. There's no report that says this is a homicide or a suicide. There's a note found where the state's expert says, I don't know, they could not determine whose signature it is. There's a witness for the defense that says that matches the signature of Mr. Gable on a suicide note. The state of Ohio did not. They did searches of some computers to look for this note. They didn't look at his work, where he probably spent most of his time, of where that suicide note was. The computer's there. There's also the test that the Avon Lake Fire Department, police department does he wraps his head in ceramic to determine, this was possible. Someone could die. Someone could commit suicide this way. And the way that they get out of it. According to testimonies, he just pokes his tongue through the ceramic. So there is the question you're asking about, could the blow have possibly incapacitated? Yeah, based on the testimony. But the way that someone would get out, or the way that someone could, even if they were experiencing a rush, or those would just be to poke a tongue out.
Well, unless they were unconscious.
Well, there's nothing that says that's a definite.
That's a what?
There's nothing that says that's a definite.
Oh, definite?
Counsel, it wasn't in either of your briefs, but are we gonna find anything in the record that addresses the size difference
I was
between
gonna ask the same
these
thing.
two?
I did not see anything in the record that addresses the size difference between these two.
Wow, okay.
And that, I think the reality of how this proceeds is this was 3 years. They did not press the charges until this trial was much later. Could be one, and I think it was alluded to by defense counsel, but you could have been, it's tough to say whether or not this is something they just brought and said, we don't really know, we'll let the jury sort it out. And that's the problem, I think, with what's here. The other problems with the DNA on the saran wrap is not, her DNA is not on the saran wrap. His DNA is on the saran wrap. The suicide note, the evidence is not clear that it's, she said she touched it, she did touch it. She did touch it. Her interview is unpleasant. If she's hiding something, she tells him everything she hates about him. She says everything that way. The interview is not someone that's being, she didn't say I killed him, which I think is what the state of Ohio would have wanted to hear, but she said I don't like him, here's why I don't like him, here's this, and this, and this. And she's very hard for the jury to get around. She's clearly a hoarder. She mismanages money. She keeps spending money. She changed none of her patterns. There's no clear saying, oh, she really did this for this reason. They imply the motive is financial, but she was mismanaging money. She seemed like she was gonna do the same thing no matter what, and it's unpleasant. And those are very hard. It's, when you look at ultimately looking at the evidence, it's only, does this circumstantial evidence arise to the level that is the forcefulness for a conviction? It's unpleasant. But the evidence and the witnesses that the state of Ohio presented do not say, oh, this is definitely do not say this is a homicide. Do not say this is this, no. Do not say this is this. They say this is a really unpleasant scene and we know she's there, but we know that they both talked about this saran wrap in this way, one killing himself, which is just truly remarkable because it means it's a very real possibility. And the defense's witnesses are on the side of this being a suicide, and they make definite conclusions, although, obviously the state disputes that, but when you look at it, cold hard fact, somebody said one thing, state didn't say it. And whether, and I know that there's obvious, but this is something that I think the jury would be particularly susceptible to seeing this as a really nasty situation, because it is a very nasty situation with an unpleasant person. That doesn't mean that it went the way the state of Ohio said it did, and they didn't present the evidence that could make the jury look at that. And the evidence that was presented by the defense is the ones that exonerate Harrington. And if they had a report that said this is definitely a homicide, this is not this is the DNA we found of Harrington here, this is not his signature, definitely, not just this is a really unpleasant woman, so she might have done this. And that's the way that this shakes itself out. I know that factually you have the transcripts of the trial, which obviously the state of Ohio could have chosen to present some things. They could have done searches of different items. They could have presented that evidence. They didn't. They just didn't. They knew they had. I believe much of the presentation around the fact that this is an unpleasant woman, and you can show her to a jury, and they're going to hang her. But I will take whatever time I have left and use for rebuttal if necessary.
Very good. You've got 3 minutes and 13 seconds. All right, attorney for Pop.
Thank you, Your Honor.
Let me see that. Poprocki?
I'm sorry?
Poprocki, is that the correct pronunciation?
Paprocki.
Paprocki,
Lindsay
okay.
Paprocki on behalf of the appellate state of Ohio.
Right. Very good. You may
Thank you, Your Honor.
proceed.
As the appellant stated, her first assignment of error is based on a manifest weight of the evidence argument, and she argues that the evidence in this case weighed towards suicide. I think it's important to look at the standard of review in this case carefully and note that in reviewing Harrington's assigned error, this court must review the entire record, weigh the evidence, all reasonable inferences, and the credibility of the witnesses. And a conviction is not against the manifest weight of the evidence, where all the evidence and reasonable inferences are considered, and it cannot be said that the trier of fact clearly lost its way. Here, the evidence established that Harrington assaulted, then killed her husband, Michael Gable, and that she altered the crime scene after the murder. Although Harrington would have this court believe the jury overlooked the greater weight of the evidence in convicting her by focusing on the difficulties in her marriage to Gable and the unique nature of the crime scene rather than the evidence which pointed towards Gable committing suicide. The circumstances surrounding the crime scene were admittedly unique. As the appellant has pointed out, Gable was found in his family den, lying in the fetal position with his pants off and completely wrapped with his head in saran wrap. We know that the cause of death was asphyxia by plastic wrap over his mouth and nose. The crux of the dispute today centers on the fact that the manner of death could not be determined. Neither expert could determine whether this was a suicide or a homicide. But both experts indicated that it could go either way, and both gave the possibility of a suicide or a homicide equal weight. This is important under the standard for review of under manifest weight, because this court has stated that an accused is not entitled to a reversal on a manifest weight of the evidence claim where there's inconsistent evidence presented at trial.
Okay,
Merely
counsel, may I
inconsistent
interrupt? I'm sorry.
Sure.
So the medical examiner said he really couldn't, or she, I don't know what it is, but he couldn't determine whether it was a homicide or a suicide.
Correct.
Okay. And they testified that, how did they testify? That they give equal weight to either one, or they just couldn't make that determination?
Based on the autopsy alone, they could not make the determination whether it was a suicide or homicide.
Okay, and based on the investigation, they still didn't make that determination, right?
They didn't make a determination as to homicide or suicide.
Okay,
The manner of death was not conclusive.
okay. So then, the evidence that you have is her DNA on the saran wrap package?
The DNA was not on the surrender.
None of the
package.
defendant's DNA was.
Okay, but I thought she had said that she touched the saran wrap though.
She touched the suicide note.
Okay, all right. So, I'm sorry, Judge Tito's saying things too, so I'm like trying to figure out how. Okay, so she touched the suicide note, so her DNA was on that,
Yes,
and the DNA was not on the saran wrap package.
correct.
Okay, and only his was on the saran wrap that was wrapped around his head.
But there was, I believe, that is correct, but the expert that testified regarding the DNA around his head said that there was, it was mostly consumed because of the amount of blood that was around his face.
Sure. I remember reading that in your brief, right?
And that's because he suffered a laceration to his lip and his face. And that was something that you touched on with Ms. Harrington's counsel, is he did have a laceration around his face, and there was a lot of pooling of blood to his face.
Mhm. And I know you argued in your brief that if he had wrapped it around himself, there should have been blood elsewhere in the room.
There should have been a blood trail to the roll of saran wrap that was in the room.
Okay, and was there any evidence as to that? Did the coroner say that, or did anybody testify to that?
That there was a blood trail.
No, that there should have been evidence of blood based on the findings, or based on the physical
I believe
findings.
the officers that were at the scene testified as to that, and that there wasn't.
No, my question I'm asking
I'm
you
sorry.
is, that's all right. The question I'm asking you is, did anybody say, based on the nature of the injuries and the amount of blood on his face, that there should have been a trail in the room? He should have been bleeding before the saran wrap was placed on him.
I'm not sure about that.
And it's my understanding that both individuals, the defendant as well as the victim or the deceased, had both talked about, she said she might kill him that way, and he said he might kill himself that way with the saran wrap.
He had mentioned it to a coworker, but she gave much more specific details to two separate coworkers on two separate occasions. She had heard apparently a story about a woman that had sat on her boyfriend's face, but there was DNA that was captured after she had done that. So she said she came up with a surefire way in which she would get away with it by placing the saran wrap around his head and then sitting on him. So,
And by sitting on him with saran wrap, there still wouldn't have been any DNA on, if you're sitting on somebody's saran wrap? Did somebody testify regarding that?
I don't know that there was testimony
Okay.
to that fact.
I'm just trying to figure it out. We'll obviously read the record very carefully.
Sure.
Mhm.
We also pointed to the motive that Harrington and Gable's marriage was in shambles. They were in serious financial troubles, and their home was on the eve of foreclosure on the eve of foreclosure on the night that they got into the intensive fight. It was reasonable, based on that fact that the jury could infer that she had a motive to kill Gable. The state's evidence showed, in addition, based on the coroner's testimony, I think we touched on this, that Gable suffered 3 impact injuries to his head prior to his death, and one of which was sufficient to cause unconsciousness. Harrington admitted in her own statement, and the evidence
Did the
showed-
coroner actually say it was sufficient, or it may have been? Did he definitively testify that that would have rendered him unconscious?
I don't want to say that he definitively said that, because I believe the testimony. I don't want to commit to that statement.
That's fine.
Being inaccurate. But the coroner did testify that the totality of the injuries, including the stun gun zaps, which were admitted to be over 20 times, along with the sedating effect of the Benadryl found in his system, had the likely effect of being very disabling or temporarily disorienting to Gable. As appellant's counsel talked about, Harrington's interview was just awful. She had talked about how she basically couldn't stand her husband and thought of him as an albatross, called him idiot brain, admitted that she really didn't have an emotional attachment to him, and as a result of his death, she was very unemotional, in a way relieved. Ultimately, it was the jury's responsibility to reconcile any discrepancies in the evidence for testimony presented at trial. Here, the jury had the opportunity to review the testimony of multiple witnesses who appeared before it and evaluate their credibility. On a manifest weight claim, it is the jury's responsibility to evaluate that credibility, and it cannot be said here that the jury clearly lost its way.
In regard to the insurance policies, I know you talked about the one that was paid out. A lot of insurance policies have a suicide, clause. So was there any evidence was it just the one policy that paid out?
I think it was an EOL that paid out in the amount of $53,000, and then
Because there was a significant amount overall, but,
and then it was reduced down very quickly.
I mean, with the other policies, though. There was no evidence, one way or the other, trial about the others.
I don't think so.
Okay, that's fine. Thank you.
Can you talk a little bit about the handwriting expert? The state's handwriting expert could not conclude that the victim signed the suicide note.
She did not conclude so. She submitted that she would have needed more signature samples from Gable because that they were necessary, because the only portion of the note that was handwritten was the signature, but she did not make a conclusive determination.
Was there any conclusion made about the typewritten part of the note?
They talked about the fact that it was oddly typed, and that there was no conclusion about who typed it.
How is it oddly typed? I remember reading it in the brief, but I couldn't
It
quite.
was left justified.
It was not
It was
justified?
left justified.
Oh, left justified.
Left justified, and it only said sincerely.
Mhm.
And the signature was the only part that was handwritten.
And she was a secretary,
She was a secretary of the church.
so assuming she types a lot.
Yes.
And the state didn't check the computer, didn't present any evidence at trial about the work computer? His work computer?
His work computer was not searched.
Wasn't there also testimony that the husband victim talked about wanting to kill Miss Harrington, or not? Am I incorrect on that? I know he
There
did have a
was
domestic
the domestic
violence.
violence.
He did, but was there any
Right.
discussion about him wanting to kill her? I could be wrong, I'm just
I
asking.
know there were instances of domestic violence in the past. Are there any further questions?
Okay, thank
We
you.
respectfully request that the trial court's decision be affirmed.
Very good, thank you. Attorney Hannock, you've got 3 minutes and 12 seconds.
Thank you. I want to talk about a couple points the state of Ohio brought up. I did have a chance to look over, and it was as clear the discussion, it was the chief deputy coroner. It was a possibility of, but not a certainty. And there is a defense expert that talks about the blows to the head in a different light. It is part of the record as well. I want to address the bleeding and how they present this at trial. First off, one of the things that is apparent is this home is completely in disarray at all times. So this was not a scene that was, Jeanne Harrington is a hoarder by any stretch of the imagination. Things are located all over. Mr. Gable's living in a den. They're being cluttered everywhere.
But the state said they presented evidence to say that even though there was a lot of items in the house, they were all boxed up neatly, so it would have been easy to see a trail of blood.
There would have been, they also present the evidence, the dust and the things that are written in there. It's tough to say where an item would be located or where the saran wrap was when somebody's living on a couch. It's not easy to say, okay, this is a house that typically everything's in the kitchen and we always walk this way to go to the kitchen. This is not a typical, clean, easy to understand.
And I assume there were photos presented to the jury?
Yes.
Arguably, if I'm going to kill myself, I'm not gonna take the time to put the saran wrap away, though.
That's true. I don't know where, but the state didn't present any evidence that says, gosh, that trail, the trail of blood was clean, the trail of blood was bleached, this came from here, and this was, those things aren't in the record either. And if there was a cut on there's a cut up, there's obviously a fight, there's obviously a cut on the lip, and we don't know what the method, the development, and when that cut happened, when that cut started bleeding, how the body reacts to, I'm sure I don't know how many treatises there are on the development of blood under saran wrap.
Did they talk about how the cut, was it like a laceration, or was it did they talk anything about that?
Yes, it would have been from a blow, basically from a blow to the mouth. It would have been a laceration consistent with a blow to the mouth. He was hit at some point.
But she admits doing it.
She admits to him.
She admitted to hitting him in the mouth?
Yeah, she admits hitting him.
Okay. Yeah, but on the mouth, I'm asking.
Yes.
Okay, all right. I didn't remember that, so that's fine.
That's what, no, I'm sorry. She denied that she ever used her fist to strike him. I apologize.
I didn't think so.
I know there's an
but-
altercation, it's.
Right. She admitted to obviously zapping him several times, 20 times
Right.
with a stun gun and hitting him, but I just didn't remember her saying she struck him in the mouth or something.
And I apologize.
That's okay, I'm just trying to get
I
and
know
again,
that-
we'll go over the record with a
There's
fine
no-
tooth comb.
There's no denying there's an altercation, she doesn't deny that, and that's certainly part of it, that's certainly part of it. The point was, I don't know where the blood, how it developed, how it went through, if that necessarily means or does not mean anything, the trail of blood.
The DNA on the saran wrap, was the testimony, was someone able to testify as to where it was on the saran wrap?
We'll hear your answer, but your time's up after your answer.
Sorry.
So,
I mean, was it the part facing him, or was the saran wrap just so?
I remember, I can't specifically go into the detail of how or where they would have tested it. My understanding is they're saying they went with it was consumed and we didn't find anything. So I don't have a specific as to, and those sorts of things, you think if they had the evidence and they had that, they were able to present that, that would have been in bright neon letters in front of the jury.
Oh, no, that's the drought time, never mind.
Good, you
We'll
want-
review the record. Okay, I just was wondering, I think it would have been in the briefs if there had been evidence either way from either side. If they'd gone through the trash or anything to see if there were any gloves, plastic gloves or anything like that.
There's no evidence presented of that kind of work at the scene.
Thank you.
All right, thank you both, counsel, for your presentations today. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail you a copy on the day it's released. Also, the opinions are posted on the Supreme Court's website. Thank you again for your presentations.
Thank you.